All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in 1CA SA17-0196, ZWB v. Foster, ACHENBACH, Real Party and Interest. Counsel, each side is allotted 20 minutes for argument. Appellant may reserve a portion for rebuttal. If you do so, you'll need to keep track of your time using the podium clock. Out of respect for counsel, I ask those in attendance to please make sure your cell phones are off or on vibrate. Counsel, we have read your pleadings, your briefs, conferences case this morning. We encourage you to keep that in mind as you present your oral argument. These proceedings are being recorded and they'll be posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, I will start with Ms. Bales.
Good morning, Your Honors. My name is Jamie Balson. I'm here on behalf of the crime victim petitioner in this case. May it please the Court. The legal definition was written into Arizona's Constitution in 1990, nearly 30 years ago, the legal definition of victim. Since that time, the term has been codified in Arizona statutes, court rules, and jury instructions. There is no case law on the books challenging this provision. Moreover, there's no case law challenging jury instructions which use repeatedly the term victim. The plain language of the constitutional provision requires that the correct legal term be used.
What is the language that you're saying requires that term be used throughout trial?
Knapp v. Martone says we have to look to the plain language of the provision set forth in the Constitution.
But what are you saying in the Constitution says, and during trial, we could never use the term the alleged victim?
No, that's not what it says, Your Honor. But what we do know is the plain language is victim, and we do know that using the term alleged victim can have an impact on the victim's constitutional rights to fairness, dignity, and respect, and to be free from intimidation, harassment, and abuse.
Why is that such an insulting term? What's inflammatory about saying the alleged victim? You would agree that there's maybe two different kinds of cases. There's a case where there's no question that a victim has been injured, has been shot, yes, and the only issue is who did it, as opposed to there are other cases where it's a sexual assault where someone says this never happened. And what's improper about just saying the alleged victim doesn't seem to me to be at all derogatory. It's more about how you say it. If you said the victim in this case, or the alleged victim with air quotes, would be insulting. But when you just say the alleged victim in this case is this person, or the victim in this case alleges that this happened, why is that necessarily demeaning or not respecting the rights of the victim?
Well, it's how it's perceived by the victim, certainly. And also because that's not what the plain language is. Adding an adjective to a legal term changes it modifies it.
But if we're going to, I'm all for plain language, but there is no plain language that decides this case. There's no plain language that says what term must be used at trial and what adjectives may not be used at trial. So I think we need to move from plain language to a balancing of the rights that are in our Constitution for the victim and the defendant. Would you acknowledge that calling, in a case of this category where the dispute is whether the crime occurred, that calling the victim suggests to a jury that the crime did occur?
No, I do not agree with that.
So you don't agree with that at all. There's no implication of saying we're not sure whether the crime has occurred, but here's the victim.
It's a legal term. There are remedies if there's a perceived prejudice that the defendant can employ. They can talk about it in jury selection. They can request jury instructions to instruct the jury that this is a legal term of art that's set forth in the Constitution.
Do we refer to the defendant as the rapist before there's been a conviction in a rape case? We we call him the defendant, which suggests that it's someone who's being tried for a crime. He's the alleged rapist at that point, but no one would condone people calling, well, the rapist then went and did this or that. It's the defendant did this. We don't call somebody the murderer during trial, and that's what they are if they committed the crime. But why? I guess I'm having a hard time understanding why we necessarily would have to use that term during trial.
Well, Your Honor, to your point, defendant is defined under the law as well, so we use that term.
But we don't say the alleged defendant
No, we
because
don't.
That's nonsensical. The defendant doesn't connote that the crime has occurred. That's just someone who's defending themselves at trial. So there's not this connotation that he necessarily committed the crime. Whereas there is that connotation when we say this is the victim.
And I disagree with Your Honor, respectfully. This term has been on the books for nearly 30 years with no challenges. And as it is acknowledged by the defendant, it has been used interchangeably.
But there have been cases where the use of the term victim has been precluded at trial altogether. And there is no appellate case law after nearly 30 years saying what you say the plain language means has to happen. That strikes me as a surprising lack of authority for the proposition that you're urging now.
And, Your Honor, if you're referring to the case law as cited by the defendant from other jurisdictions.
No, I'm not.
Okay.
Just to be clear, I'm not referring to any other jurisdictions. I think Arizona has a unique constitutional scheme, and it deserves to be handled in that context. We don't need to look outside of Arizona. But I am saying that trial judges have for years wrestled with the question of how best to manage the presentation of evidence. And not once, to my reading, has an Arizona appellate court ever said the plain language of the Constitution or the statute require that no adjectives be used.
Well,
and that suggests to me that the law may not be as clear as you're positing, that the law may be that judges have discretion under the rules of evidence to manage the presentation of evidence to make sure that it's fair to everybody, that the victim is not deprived of dignity, and as Judge Catani said, there are ways to say alleged victim that would be wholly improper. But that the victim is not deprived of dignity and the defendant is not deprived of the presumption of innocence. So you suggested that the defendant could ask for jury instructions.
correct.
What if there was a jury instruction that read something to the effect that the defendant is proved innocent, the state must prove that a crime occurred. The victim alleges that on such and such a date, such and such happened, and the alleged victim, in the jury instruction, the alleged victim will or won't testify, something to that effect. Would you have a problem with that instruction?
So what Your Honor is asking me is the term victim and the term alleged victim in the jury instruction.
Well, that's one step along a continuum, and I'm curious about your reaction to it.
In my view, the proper way to give the jury instruction is to say it's defined under the Arizona Constitution, because when you start adding modifying language, you're changing it.
What if then you said this term is defined under the Arizona Constitution, but you are directed that there is no evidence at this point, because the state hasn't begun its evidence, there's no evidence at this point that the victim actually suffered at the hands of the defendant? Because that, to me, would be legally accurate, consistent with the plain language, and yet incredibly demeaning. And I would not favor such an instruction, but wouldn't you have to agree that that wouldn't offend the law?
I think the language would have to be fleshed out to match the definition of victim in this case, because I still think the most proper route is to follow the word that's written in the Constitution.
Could I ask just kind of a somewhat unrelated question, but there are other people who are victims. In a murder case, the decedent's parents are victims. But that doesn't necessarily tell us how we're going to refer to them during trial. Can we not call them the decedent's mother is testifying, it seems a little, jurors might be confused to say the victim is now going to testify. The victim number 2 is going to testify, and the victim's mother is legitimately a victim under our Constitution, and we want to make sure she has all the rights afforded to her. But that doesn't, to me, answer the question of, do we necessarily have to call her the victim during trial? Why does treating her with respect necessarily go to the word that's used during trial?
Well, in that case, it would depend how the victim felt about it. Did the victim find it a violation of the fairness, dignity, and respect?
The victim wants to be called, and here I'm talking about where it's the mother who is a victim, and she just insists, I want to be referred to as the victim. Is everyone obligated during trial, even though they think that will be confusing, are they obligated to refer to her as the victim?
I think that might require some more looking at the statute, because I believe in other areas of the law, victim's representative is used, and in that the particular case you're setting forth is different from this one. So I would need to analyze that more specifically on those facts, and if there could be an agreement that victim's representative with that victim, that hypothetical victim
well, a victim's representatives usually could be an attorney there representing the victim. There's a statutory victim. The point I'm trying to make is simply that it's the Constitution defines who the victim is, but that it doesn't necessarily tell us, and as you've acknowledged, there's nothing that says, and this means that the only way that they can ever be referred to during trial is as the victim. So I'm not sure where that leads us, I guess, if you don't have a separate thought on if it's the mother of the murder victim.
I don't feel like I can answer that without being able to speak to a client and kind of explain that it might be confusing.
Counsel, where I'm having the rub here is the due process right of the defendant and your client's state constitutional right under the Victims' Bill of Rights. Give me your remedy then. Give me your fix. What do you want this court to fashion in terms of an order or a remedy that can reconcile those two competing constitutional rights?
Yes, and this was brought up in Roper and also brought up by the trial court and the defendant. So what the trial court set forth was that when the defendant's right to due process conflict with the Victims' Bill of Rights in a direct manner, then due process is the superior right. And that's not what I'm questioning. What I am challenging is that if that is the case and we stop there, it essentially wipes out all victims' rights. It erases the protections. What they did in Roper was different. The court in Roper...
What protection is being erased, though, by saying the alleged victim?
But because it's not the language we use in the law, and it violates the victim's right to fairness, dignity, and respect, and to be free from intimidation, harassment, and abuse.
I'm concerned, though, about fairness, dignity, and respect. I really am. But there are many people who are legally victims who are offended by the term victim, who find that term itself is disrespectful. They would prefer to be called, for example, survivors. And if they prefer that, should we also say that they're entitled to be called that?
No, Your Honor. I have clients who have raised that with me. I have colleagues who have raised that very issue with me. And what I tell them is it's a legal term of art. And when we're in court, when we're representing victims, we have to use the legal terminology that has been set forth by the authorities. In this case, it's the Constitution.
But again, I come back to the fact that the plain language doesn't say you shall call a victim and nothing else at trial. What if a victim prefers to be called by his or her name?
And that is not offensive, using their name.
It's not offensive, but it's also not the legal term of art. And I assume that if the court yielded to that request, you wouldn't have a problem with it.
No, Your Honor, using a pseudonym would be acceptable for the victim in this case. It was not addressed by the court. It was not addressed by the defendant. However, I do think in order to give the court's guidance, a full analysis of the constitutional rights is important, because in Roper, what happened was The court determined that the defendant's rights were paramount in that case. But it didn't stop there, because to stop there would erase the victim's rights. To just say they're paramount and not conduct a further analysis erases it.
I don't think anybody in this room is considering doing anything to erase all victims' rights. I don't think that's a worry. But we have a discrete question here, and I guess I need to come back to my question. If the victim wishes to be called by his or her name and not have the term victim used at trial at all, is that okay?
That would be a resolution on a very narrow issue in this case. Yes, it would be okay.
Okay, but if that's okay and we're not using the legal term of art, then have we violated the plain language?
But it's different, because we're not adding modifying language to the victim's name. We're not saying the alleged and then victim.
Okay, what if the victim wants to be called the victim John Smith?
Is the victim's name John Smith?
Yes, let's assume it's John Smith. And the victim wants both the name and the word victim. That's not the plain language either, but I assume you wouldn't have a problem with that.
If there was no objection, I wouldn't have a problem with it. I would have a very real conversation with my client about what the law says and what the terms say, and confusing that and taking away from the criminal case. Which,
isn't it just as demeaning, to the extent we're going to call it demeaning, to say the victim alleges that she was sexually assaulted? For the victim, they're sitting there thinking, I'm not alleging anything, this is what happened. I mean, I understand that would be unpleasant for the victim, but that doesn't seem that different to me, to say the victim alleges that she was sexually assaulted, as opposed to the alleged victim in this case is Mary Smith.
And Your Honor, I take your point, but I do think it's less demeaning, because what the statute says is that a victim's, I'm sorry, I have the wrong part. Here it is. Victim means a person against whom the criminal offense has been committed. Now, if we took Your Honor's idea and changed it to victim means a person against whom the alleged criminal offense has been committed, that is less demeaning to my clients. It is less demeaning to the people I represent. I understand your point is that.
And I guess we come back to if it's demeaning, it suggests that a crime has in fact happened, which kind of runs afoul of the defendant's due process rights. If it's demeaning because it suggests that there has been a crime, then it seems to me it's getting pretty close to making a suggestion that the crime has occurred.
So you're saying by inserting the word alleged, as I just read it, is, I'm sorry, I'm not following your question.
Well, I guess just ignoring my previous question, just shifting over to the other concern that's been raised, is just the due process concern that the defendant has. If the reason the victim doesn't like this is because it suggests, by saying the alleged victim is suggesting that there wasn't a crime, the opposite should apply when we're saying the victim is, there's a suggestion that there has been a crime, and that does start to infringe on the defendant's due process rights.
Well, I'd like to tell you why what Roper did and what we're held to in Roper is different from what happened here, because I think that may answer your question. So in Roper, it was a privacy right of the victim and the defendant's constitutional rights. And what they did in Roper to make it very narrow, the victim's rights violation, was that the court conducted an in-camera review of those medical records, the challenge documents. The review was limited in scope to the victim's multiple personality issue, but the court denied disclosure of other medical records in regards to undefined issues, and the court denied a general waiver of the victim's doctor-patient privilege. So I think the court here, the trial court, could have conducted an analysis taking into consideration, instead of just saying the defendant's rights are paramount and stopping there, they could have said, how can this perceived prejudice be cured through jury instructions, jury selection, strategic questioning, and closing argument, because there are protections for the defendant for this perceived prejudice that they're raising. I'd like to save my time.
Thank you, counsel. Mr. Hamby, go ahead.
Thank you. Good morning, Judge Bean, Judge Catani, Judge Swan. My name is Joey Hamby. With me is Associate Counsel Brent Graham and also Omar Gurion. We represent the real party in interest in this matter, Mr. Derek Achenbach, and we're asking this court to uphold the decision of the trial judge. Words have meaning, and that's what we have been debating about this morning, is what is the meaning of the word that is being used here, victim as opposed to alleged victim.
Would you have a concern if it's a case where there's no question that somebody's been injured and they're a victim? Would you concede in that case that it would be okay for the Superior Court to say you must refer to them as the victim in this case?
And let me make sure I understand that your question correctly. In other words, we have a person who has truly been injured. The question is just, is it this defendant?
Yeah.
And the answer to that is based on the plain language of the statute of the Constitution under NAP, yes. And here's the reason why. As Ms. Balson repeatedly says, victim is defined in the Constitution. The Constitution says victim means a person against whom the criminal offense has been committed. That's the criminal offense for which this defendant is on trial. I know there are some disputes or some different articles in law reviews and different cases talking about when we have a clear victim as opposed to one where there's a dispute whether a crime happened. But for that defendant at trial, there's no dispute. He's on trial for committing an alleged offense against the complaining person.
But in that case, there's no question, as a matter of fact, that the person is a victim. If the person was found having been shot on the street and taken to, there's adequate documentation that this person was the victim of an assault, let's say. What defendant could argue credibly that his status as a victim is only alleged? I think the defendant could at that point argue credibly that the status of the victim of me is alleged. Or take an even more difficult case and say that there's no question who shot the victim. The only question is one of justification.
In other
At
words,
that point, the victim to me is without question a victim. The question then becomes whether there's criminal liability.
I would disagree with the last hypothetical, because if in fact it is, for instance, a justifiable homicide where a person is being attacked and they defend themselves, at that point I believe we're not going to call that a crime. We're going to say that it was justifiable, and while it was a killing, it was not a criminal offense. So again, I would say that's not a person.
I don't want to go too far down a hypothetical that doesn't get us back to the case at hand, but I would just say that the fact that a justification defense may apply doesn't suggest that the elements of the crime haven't also been proven.
And depending on the hypothetical, I think we could probably agree on some of that. But I think what's clear for our purposes today is what we clearly have here is a case where there is an absolute dispute as to whether the underlying facts actually occurred. So for purposes of this case, which we've all briefed and argued, I think there is no dispute that what's going on is Mr. Achenbach says this did not happen. And if you require my attorneys to get up and say this is the victim, that word has meaning.
Well, why can't the attorneys just mentioned by ZW and not say victim or alleged victim? Why can't they just go with that and make it an easy case for everyone involved, including the trial court?
Sure. Let me answer your question, but then let me spin it out just a little bit further. We absolutely can refer to people by different names or statuses, no question. Let me spin it out a little further. What happens in trial when, as a defense attorney, you're going to have to get up and confront and cross-examine this person in the crucible of cross-examination, as Justice Scalia called it, and call them a liar to their face? I would point to the case law that Ms. Balson points to in Roper, because treating somebody with dignity and respect is not the same thing as agreeing with everything that they say and with assertively and aggressively disagreeing with them. Roper says a defendant must be afforded an opportunity to effectively cross-examine or impeach the victim, and they use the word victim there, and she must be allowed to cross-examine even on matters that may be potentially revealing, embarrassing, or prejudicial to the victim. Now, it's going to be up to the trial court to determine how far can you go in embarrassing, impeaching, and providing revealing information about a particular victim without violating the right to be treated with dignity, fairness, and respect.
What if the state were allowed to refer to ZW as the victim, and the defense were free to say the alleged victim as long as the state didn't do it in a disrespectful manner?
That's an issue that we're not here about. We're actually here about
No, that's
defense
why it's
being
called a
precluded.
hypothetical.
Right.
No, it's a hypothetical.
Exactly.
If that were the order, would you be comfortable with it?
I would be uncomfortable with it.
Comfortable was a bad word.
Okay.
Would you believe that the order was an abuse of discretion or a violation of either side's rights?
Given the common definition of victim and the constitutional definition of victim, I would object to that. And I would ask to take it up either during a special action or at the end of the case, because a victim as defined in the statute is the person against whom the criminal offense has been conducted.
So has that been raised? Have you, or are you aware of other cases where defense counsel has filed a motion saying the prosecutor should not be allowed to refer to the crime victim as anything other than the alleged victim?
I cannot tell the court that I have a knowledge of any reported case on that. Certainly from the trenches, I can tell you there's frequent fighting going back and forth as to how people are going to be referred to.
Isn't this something that's a bit self-correcting in terms of, that's not a good way to couch it, but if the prosecutor overdoes it, if defense counsel comes in and says the alleged victim, even if it's in a more demeaning way or even just the alleged victim, where it's absolutely clear, it seems to me the prosecutor can come in and say, well, the alleged victim here, this is what happened. There's nothing alleged about this. This is someone who's been victimized. But the defendant has the same opportunity to the extent the prosecutor is saying, well, the victim, well, they're calling this person the victim, but this is what happened. The defendant didn't do this. This person is not a victim. I'm not sure that these words are necessarily pejorative. I certainly understand your point that it couches it as this crime has occurred. But in terms of just as a pejorative term, victim or alleged victim, I'm not sure I'm understanding that.
So
Not really a question, sorry.
Exactly. No, I hear what you're saying, Judge Catani, and I think that is a legitimate point. I will tell you that I think this is what we're in the end arguing for, is to let the trial judge be able to have that discretion. I could see circumstances, Your Honor, where in fact a prosecutor could get up and make statements somewhat similar to what you're saying, and I would probably say I'm not going to object to that. I'm going to get up and I'm going to give the other side to the jury, or it might not even be objectionable. I can give you examples where there's frankly no question at all that a crime was committed, that the defendant was the person that committed the crime, and what we're really arguing about to the jury might be something such as life and death. Well, as a defense attorney, you're going to lose a lot of credibility in front of the jury, and not to mention, be saying things that aren't true if you're denying that in fact this is a victim and that your client in the end is the person who has committed this particular offense. What you're really arguing about is what is the sentence at that point in time. So I can see times when your hypothetical would come up, but what we're here about today is to allow the trial court to exercise that discretion in what will be, in many cases, a very heated event where you have two people saying the opposite of each other and it comes down to an issue of credibility. One of those people is lying.
Well, Mr. Hamber, you started your argument talking about how words have meanings, and I agree. But early on in Chapter 40 of Title 13, a person is given they're designated as a victim 7 days after an indictment has been issued. They get the moniker, the designation as a victim. So under your analysis, when would it be legally correct then to call somebody that's a crime's been perpetrated against, when would you call them a victim?
So the Constitution doesn't give them a right to be called a victim. It gives them certain rights as victims. So that's the first difference that I would have. I don't read a single part of
Well, it says
Article
the
2.
prosecuting office shall give the victim notice of the following. So they are calling them a victim.
Right. But Judge, I cannot find anywhere in the Constitution or in Chapter or Title 13 where it enumerates a right to be called a victim. Now, this is a lengthy constitutional amendment. It goes for 12 numbered paragraph that lists the specific rights. Not a single time does it say, and that person has the right to be referred to as a victim.
Well, maybe because it's just axiomatic.
Well, here's the reason why it is not, Judge. If you look in the Arizona Constitution, Article 2, I believe it's Section 24, the United States Constitution, the Sixth Amendment, we all refer to those as the rights of the defendant at trial. They don't use the word defendant, but we all believe they do. They talk about the accused, and it's very clear. That's the black letter. Nobody's going to stand up and argue that you must refer to this person as the accused. Now, that's inherent in the definition of defendant, but we're not going to constrain people by saying you can only refer to them as the accused, not the defendant, or not Mr. Smith or Mr. Jones. You can refer to people in many different ways as long as they're truthful and as long as they're not an intent to, cast aspersions on people or insult them. That's what the court's there to do. The court is there to make sure that everybody follows the rules in that regard.
So under your analysis, when would a victim of a crime, or when would a person whose crime had been perpetrated against be legally entitled to the term or to the being able to be called a victim? Would it have to be after guilt?
So for purposes, again, of the title, I don't think either the Constitution or the statute say at this point in time you become a victim. Because I'll give you another hypothetical to follow up on that one. What happens if a person is convicted, they're sentenced, they're sent to prison, and 10 years later it comes back they're actually innocent? Do we go back and say you're no longer a victim? Of course we don't.
Well, I don't know. I think the statutes kind of contemplate that after an acquittal or a setting aside of a conviction, that's exactly what it's contemplated.
Actually, it doesn't contemplate changing their name. It says the rights end at that point.
Their rights as a victim.
Their rights as a victim, exactly. Not a right to be called a victim. That is nowhere in the plain language, which is what Knapp versus Martone says. It is the plain language of the Constitution that must be followed. We're not in the business of writing into the Constitution things that should be there. I know that it was not the legislature that drafted Section 2.1. I think there were some interest groups involving a number of different folks that drafted 2.1. It stands out as one of the lengthiest and wordiest amendments and enumerates numerous rights. At any point in time, that right to say to be called a victim could have easily been inserted in there. It was not. Nobody has contemplated that. And again, it would, at that point, that I believe falls afoul of numerous rights for the defendant. Due process rights, fair trial rights, your right to confront and cross-examine. It shifts the burden of proof. It's your right to deny that these things are true. These are numerous rights that are going to be
Isn't that
undercut.
remedied with the preliminary jury instruction on burden of proof and presumption of innocence, both preliminary instructions and final instructions?
So why confuse the jury? Why send them multiple messages? Why say it's always the state's burden, but by the way, this person is a victim? Why do that? Why send that message? Why cross that line when it is absolutely
That's something
not
a very
insulting?
artful and skilled defense attorney such as yourself, Mr. Hamby, could take up I'm sure, very skillfully in front of a jury.
It is undoubted, Your Honor, that skilled attorneys on both sides can work their way around issues. That's not the question. The question here is, does the Constitution require this? Does the Constitution require that a truthful, factual, and respectful descriptor be precluded from being used at trial? What about, again, if I must get up and confront a person, a complaining witness, a victim under the Constitution, and I must say you're not telling the truth? if the court goes down this road, at what point in time are those handcuffs going to get to the point where we cannot defend our client at all? I would tell you this is the point right here, where the court puts a judicial stamp of approval on the allegation, a judicial stamp of approval on the accusation. That's what Judge Foster found. He found this is too close, and it is, more than that, he found it is not disrespectful. So for this court to move forward and to do something different, you're going to have to find, first, that Judge Foster abused his discretion. He absolutely did not. Petitioner filed a lengthy motion. She had opportunity to be heard on that motion. Judge Foster issued a 5-page single-spaced decision covering all of the relevant constitutional and statutory and case law. There was absolutely not arbitrary, capricious, or an abuse of discretion. So our argument is that in no way, shape, or form does saying the word alleged victim, which is an accurate and truthful statement, cause any injury. I would ask the court, our motion is actually attached in petitioner's index. It is completely respectful. There is no use of written air quotes, as Judge Gattani mentioned. There's nothing in there that is disrespectful or injurious to a victim in any way, shape, or form. Nothing further?
Thank you, Mr. Hamby.
Thank you.
I would like to point out some persuasive information to the court. A case that recently was heard on September 9th of this year, just a few days ago, in the District Court of Montana, cited the Ninth Circuit, and it found that a jury instruction was an adequate safeguard for any potential prejudice that might flow from the word victim. It found persuasive to the court was that the term victim had a legal definition that describes the individual's status in the case.
Was that in a case where there was a question about whether any crime had occurred, or?
The case that was cited by the Ninth Circuit it was about a child victim, and I believe they also spoke about the term child victim. The court noted in that case that the term alone did not comment on the
was it a case where there was so someone was disputing, was it a child molest case, or was it?
It was a child molest case disputing the use of the term victim.
But that was a case that was an appeal from a judge's allowing the use of the term victim to be used. It didn't consider for a moment whether a state constitutional amendment prohibited the type of order that the trial judge here has issued. And it gets back to a fundamental question, which is how much discretion does a trial judge have over how the evidence is presented to ensure protection of victims' rights?
To ensure the protection of the victim's rights and the defendant's rights is to put things in place that protect them. And in this case, it's through jury selection, through jury instructions, strategic questioning, and closing argument. This has been on the books for nearly 30 years. It has not been challenged. The Rajis have not been challenged, even though they use the term victim repeatedly. It's significant. Because right before we're sending a jury back to deliberate, the judge is saying the victim, and going over the jury instructions, and yet no one challenged it in all that time. It's significant. The reason they haven't challenged it is because it's not prejudicial to the defendant. There are remedies. The defendant can take action to address that perceived prejudice. I see that's my time, Your Honors.
Thank you, counsel, for your briefs and your presentation here today. I do appreciate it. We will take the matter under advisement and issue a written order and ruling in due course. The court will now stand adjourned. Thank you.